The case study of Parham versus JR. In the 1970s, the Georgia statute allowed parents to voluntarily omit their kids age 18 and under to a mental health hospital with an application. This had many downfalls as child's rights could be violated. Two boys, amongst many other kids, fought the Georgia statute. JR was one of these kids. When he was 3, he was removed from his biological family as they were deemed neglectful by the county. By the age of 7, he had been to 7 different foster homes. His last foster family requested for his removal based on behavioral issues, and Georgia State Child Service Agency brought him to a mental health hospital.
Another appealee was JL. JL's mother requested his indefinite commitment to the hospital after having him take treatment for 2 months. He was 6 years old. When her request was denied, JL's parents gave up their parental rights in 1974. As medical knowledge about the mentally ill and public concern for their condition expanded, the states, aided by federal grants, 10 of the hospitals have sought to alleviate the human tragedies of seriously disturbed children. Ironically, as most states have expanded their efforts to assist the mentally ill, their actions have subjected to increasing litigation and heightened constitutional scrutiny.
JR was interviewed by the hospital as he moved through treatment. Medical professionals found that he suffered from an unsocialized, aggressive reaction of childhood. Later, he brought a federal class action lawsuit against the hospital's chief medical officer and a few state officials, one being James Parham. JR said his 14th Amendment was not being held. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, where the Georgia State Hospital violated this amendment and forcing children aged 18 and under to be admitted into the hospital.
The superintendent was also allowed to admit these children if they had evidence of mental illness and were suitable for treatment. This also led to argue that their parents were institutionalizing their kids to get rid of them. The person who was on the appellant's side was a man named R. Douglas Lackey and the Georgia mental health officials. The Berger Court led this trial, Chief Justice Warren Berger to be precise, alongside Potter S. B. White, Thurgood M. H. Blackman, and Lewis P. Jr. William Rehnquist.
The basic question of this case was how Georgia would go against basic societal rules already embedded in our system to have the state intervene between a parent and a child, as there is always the possibility that a parent is unfit for their role. Parents have a responsibility for bringing up their child, and it should be their choice for release. However, even if a parent should have a say about their child going for a mental health hospital, they do not have an absolute discretion over the decision.
The decision maker for the child to be admitted into the hospital should be a neutral fact finder and not the parent. A background check should be done on the child to make sure the requirements for admission are found. An exacting constitutional scrutiny must contain a formal adversary per admission hearing to protect the child's rights. In simpler terms, this means the child must file a formal complaint against the unconstitutional law.
The district court ruled that the statutory involuntary committed and holding of juveniles was unconstitutional because holding a juvenile had a severe deprivation of the child's liberty. They required that the child be heard and evaluated before they are institutionalized. This led to the ruling that periodic review of the child is required to evaluate if the kid should still be institutionalized. However, an initial evaluation before being inducted is not required. Originally, the Georgia State Hospital was holding these children for an average of 346 days. The new ruling made it so an evaluation must be made after 30 days to prevent holding children unnecessarily.
Parham lost to a 4-judge court of the district court, finding Georgia's statute unconstitutional. They found that this commitment seriously deprives a child's liberty and their interest. To protect that interest requires notice and an adversary-type meeting. Overall, the case was first fought on December 6, 1977, re-argued on October 10th of 78, and then finally decided upon June 20th of 1979. The kids won.